this meeting to order. Thank you for joining us during our weekly hybrid MLS breakfast meeting. My name is Tomas Wong from Coldwell Banker George Realty, and I am your September program chair. Thank you. Now, please stand for the Pledge of Allegiance. I'm going to call Carlos. Pledge of Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you, Carlos. Now I would like to call Michael Sanchez, who's going to lead us with the inspirational quote.
Everybody, thank you so much for making it this morning. In honor of Hispanic Heritage Month, I would like to go ahead and share this quote by our well-known Carlos Santana. The most valuable possession you can own is an open heart, and the most powerful weapon you can be is an instrument of peace. Thank you very much.
Thank you, Michael. As I would like to recognize this month's celebration, the National Hispanic Heritage Month, from September 15 to the October 15. So cheers to the Hispanic community. Hope you guys enjoy the holidays with friends and relatives. And also we are celebrating the Mexico Independence Day, September the 16th. It is Mexico Declaration on Independence from Spain in 1810. So at this time, I would like to welcome the first time our guests are here today. So could you stand up and introduce yourself and share a little bit about your organization. I know we have a few people from the guests today.
Tomas, can they come to the mic?
Would you like to come up front and use the microphone, introduce yourself? So what happened is this meeting is hybrid, so the people, the audience on via virtual, they'll be able to hear what you say.
I think I like this too much.
Okay.
Hello, everybody. My name is Tabitha Bonando. I'm here. I'm representing LASA. And
Closer to the mic.
You guys can hear me?
Yes.
All right.
That's
Okay.
better. You can.
Here we go. So my name is Tabitha Bonando. I'm here representing for LASA. We have a program called RPSS that is also associated with PATH here. So I do have information for that for you all, anyone who wants to know about that, or any other general questions about what we do, program funding, things like that. So thank you for having me and for breakfast and coffee.
Thank you, Tom. Go ahead, Juliana.
My name is Juliana Lomalio, and I'm here from Union Station Homeless Services, and I work in the Housing Location Department. So I'm here with LASA and PATH. All together, we work as a team, and our department is focused on landlord mediation, acquisitions, making sure that we are prioritizing the needs of the landlords as well as the yes, and advocating for property managers and landlords. Many of us have some property management background, so we're very familiar with that side of it as well. And we just are here to advocate for you and learn from you as well, so we can all do better and work as a team.
Good morning, everybody. My name is Mikey Sanchez, and I'm here on behalf of Lisa of Los Angeles. I'm the Housing Partnerships Program with PATH, and our department specifically builds partnerships and collaborations with housing providers in LA County and property management companies to advertise your units on our website, Lisa of Los Angeles, absolutely free of charge. And we partner up with community partners like Union Station, and on behalf of LASA to go ahead and fill up your units at a much faster rate and provide ongoing professional support during the partnership process and after the participant is housed. I brought my business cards, which I will be passing out at the end of our presentation. So if you would like more information on our program, you are more than welcome to contact me. Thank you very much for having me this morning, and I look forward to working with all of you.
Thank you, Michael. Would you like to introduce yourself? How about the two of you? Would you like to introduce yourself? You guys can line up.
Good morning, everyone. My name is Peter Vasquez, and I actually work directly with Michael and Thomas. I am the housing specialist for SPAs 3 and 7. So we work directly with case managers, and I have my own leasing specialist. I don't believe they're here today, but in case you guys do work with me in the future, their names are Nielska and Jaden. And yeah, I look forward to working with anyone who's interested in working with Lisa Butler. Thank you.
Thank you.
Real quick, like he said, my name is Thomas Harper. Work with them. We work and live in the SGV, so great to be here. Thank you.
Okay. Okay, a few housekeeping tips. All participants will be muted upon entry to the MLS breakfast meeting. And should you have a question or a comment, please remember to enter it into the chat box. Please remember to join us weekly as we will have our hybrid MLS breakfast meeting every Thursday at 9 a.m. As always, this meeting is being recorded and will be available online on our YouTube channel at West San Gabriel Valley Realty. Remember to follow WSGBR social media on Facebook, Twitter, and Instagram. You can also watch all our pre-recorded videos on YouTube and join our text message group for updates. Text WSGBR to the number 888-304-4055. Right, CRMLS rules and regulations, section 8.2. Participants and subscribers filing listing with the MLS shall have a written listing agreement with all the necessary signatures in their possession. The Association of Realtors and MLS shall have the right to demand a copy of the documentation to verify the adequacy and the information reported to the MLS at any time. Visit www.gocrmls.org/compliance for more information. Today's agenda consists of our affiliate spotlight, Unita Wu from Home Warranty of America, followed by our guest speaker, attorney Jean Klinkert. Just a reminder that to be eligible for today's drawing, you must be a WSGBR member. We will be having an attendance drawing, Amazon gift card drawing, and the 50-50 raffle. Today, our affiliate spotlight will be brought to you by the affiliate committee, Chair Brandon Chorosky, and the Vice Chair, Joseph Nguyen. Please remember to support our affiliate with your transaction. So our affiliate today is Unita. Unita, take it away, please.
Thank you, Thomas. Thank you so much, everyone. Hi, for some of you guys don't know me, my name is Unita Wu. I'm with Home Warranty of America with a 13-month home warranty. Balin, next. Oh, these are my information. I'm Chinese. I was born in Indonesia. I come here when I was like 14 years old with my younger brothers. And my background, I used to work for RE/MAX as an agent assistant, and I was working for a title company for another 4 years, and I'm currently working for Home Warranty of America for the last 15 years, my 15 years anniversary. And we have different type of brochure here, guys. So then if you do need like some kind of brochure, we do have an English, Chinese, Mandarin, and Indonesian. Please reach out to me. I'm here to help you. And these are the photo, like for me and my family. I was really blessed that I was be able to spend some time with my family for my mom's 70th birthday. So these are my two children, Simone and Avery. They're getting bigger. For some of you guys probably see me when I was still pregnant, and now they're getting bigger. One of the things that I'm very grateful is like my daughter and I like share the same birthday. So as you see, like we celebrate birthday on the yearly basis. And I'm always not either getting a cake or my cake is smallest, right? So the kids always get that biggest cake. When I'm not working as well, my husband and I are with the family, we spend time with fishing. So then we could be able to spend some family time. These are like our family pictures. So we spend time together as a family, and these are the nephew and niece as well. We're able to take this family picture, so really blessed to be able to do that. So if you guys do need, well, this is the last slide. So we were really blessed to be able to spend time with our good friends, to be able to go to USC game, the last game. It was really fun. So, you know, we're here to help you. And Unita Wu from Home Warranty of America. I do speak English, Chinese, Indonesian, and Mandarin. And I do pride myself on the customer serving and helping out with my client. We're 13 months home warranty. So if you guys need any help on the home warranty, please reach out to me. Thank you again for all your continued support, and I'm looking forward to be working with you all. Thank you.
Thank you, Junita.
Thank you, Thomas. Thank you, everyone.
Okay, we'll now have our affiliate introduction for today. All affiliates present, please line up at the front. Please, no promotion. This is a morning greeting only. Yeah, go ahead.
Okay. Hi, good morning, everyone.
I'm sorry. I apologize. I'm gonna do virtual first. I'm always one step ahead. I apologize for that. Mark, are you there?
I am. Can you hear me?
Yes.
Okay. Good morning, everybody. Mark Wu with AMS Insurance Agency, 34 years in the business. Have a great caravan. I'm here for your home and condo HO6 policies.
John Wax.
Good morning, everyone. John Wax with Snap NHD for all your NHD tax environmental needs. 28 years of experience and in the business to help you. My information's in the chat. Have a great caravan.
Thank you. Thank you, John. Junita Wu again.
Hi, Junita Wu from Home Warranty for America, your 13 months home warranty. I will put my information on the chat too. Have a wonderful caravan. Thank you.
Thank you. Judy Chu.
Good morning, Judy Chow from AA Capital Investments, Senior Loan Officer. Have a great day. I put my information in the chat. Thank you.
Thank you. Teresa Lam.
She's not here.
Oh, she's not here. Angie.
Let's try this again. Good morning, everyone. Angie Tang, First American Title. Thank you.
Good morning, David Tran with Home Warranty. Have a wonderful day and make sure you buy a ticket before you leave.
Morning, everyone. Chase Kerr with Norris Properties.
Morning, everybody. Oriana Chan with Prime Lending. Have a great caravan.
Good morning, everyone. Jacqueline Chu from Champion Escrow.
Good morning, everyone. Chris Hahn with Jam Mortgage. Have an awesome day.
Good morning, Nancy Chan, Lawyers Title, 41 years in the industry.
Hi, good morning. I'm Daniel. I'm a plumber.
Good morning, everyone. Yolanda Martinez at WFG National Title Company. Have an awesome day.
Good morning, everyone. I'm Lucia Tam, representing CARPA, Chinese American Real Estate Professional Association. Stay cool in the next wave of heat. Stay cool.
Thank you, Lucia. Today we have no listing, right?
No listings.
Okay, so let's move on with the program. So before we welcome our guest speaker today, I would like to read his intro, his bio. So Jim Klinkert is lead trial counsel for Klinkert, Gutierrez, and Nebo. A veteran of many dozens of trials, Jim has tried cases in various states and federal forums involving such diverse areas of law as public and private construction, employment, title, contracts, escrow, business interference, partners and shareholder disputes, broker liability, professional malpractice, lender liability, commercial transaction, estates, elder abuse, broker and contractor license revocation proceedings, wrongful death, and major personal injury. Jim graduated with honors from Loyola Law School in Los Angeles in 1984 and began practicing law the same year. A former real estate broker, Jim has been active in organized real estate for more than 2 decades as an advisor to the local Realtor Association and a member of the California Association of Realtors Legal Affairs Forum. Outside the courtroom, Jim is an accomplished classical pianist. So with a warm welcome, let's welcome Jim Klinkert.
See you. Is that better?
Yes.
Okay, now we're good to go, I think. Good to see all of you. Albert suggested the topic of COVID-19 and legal issues, and it got thinking about it. It's actually pretty timely. Depending on who you believe, the pandemic is either over or it isn't over. But regardless, we're going to be dealing for several years with the fallout of the pandemic and issues related to COVID-19 and whatever else might be coming down path ahead of us. And I thought this morning.
There's no clicker. I'm sorry. I will, yeah, I'll navigate.
Okay, well, sure. So I thought this morning we talked about 4 things. First of all, probably the area most impacted by COVID-19 for real estate professionals has been landlord-tenant relationships. They've been crazy. I want to go over several things with that. Another aspect that comes up when you're talking about COVID-19 is contract performance. When does somebody have the right to get out of a contract because of COVID? What kind of arguments can the person make about getting out of a contract? Obviously, risk management is an important thing we all need to consider, and I want to talk about some issues with that. That landscape's changing quite a bit, but still there's some things we need to keep in mind. And then lastly, I'll spend a couple minutes talking about the state of the court system and the impact of COVID-19 on that. So let's talk first about some landlord-tenant issues. Some of you who have owned property or represented landlords or are involved with tenants know COVID-19 was a miserable experience for just about everybody involved in real estate. Certainly tough on a lot of the tenants, but even more so, I think it was miserable for those of us who own or manage rental property. And if you go back in time, we're kind of past a lot of this stuff now to a large extent, and we'll kind of go over the history of it. But if you recall, back when COVID first descended on us in March of 2020, there was a rapid succession of government responses to the problems that COVID-19 is causing. And the first thing that happened is we started seeing some local city and county ordinances come about looking to protect tenants from the impact of COVID-19. Those started showing up in March and April of 2020. Right on their heels in April 6th of 2020, the California Judicial Council, that's the organization that sort of runs the court system. It came out.
Yes. Oh my gosh, I'm so sorry. My apologies, sorry.
Technology. The Judicial Council adopted an emergency rule that basically made it impossible to get an unlawful detainer summons issue. And the unlawful detainer system is such that if you have a tenant who's not paying rent, California law provides a summary remedy to get them out of the property so you can move on. And if things work well, that takes just a matter of a few weeks. And the process works that you have to give appropriate 3-day or 30-day or 60-day notice, whatever the case might be. Then you file an unlawful detainer complaint. Important to establish jurisdiction over a tenant who hasn't been paying its rent, you have to serve that tenant with a summons. And when the Judicial Council decided in their emergency rule number 1 that they weren't going to issue a unlawful detainer summons, that ground all possible evictions to a halt. If I have a tenant in a property and I need to get them out, and I can't get the clerk to issue an unlawful detainer summons, I'm dead in the water. That tenant's going to stay there as long as they want until that rule is lifted. So that rule was adopted without much fanfare, but it was the death knell to landlord's ability to control situations with defaulting tenants. And then shortly after that, the Centers for Disease Control issued a moratorium on evictions for people impacted by COVID-19. And then the biggest piece of legislation was the COVID-19 Tenant Relief Act that the California legislature passed also in 2020. The combined effect of these 4 things was that essentially tenants had all the power and landlords had no leverage whatsoever to deal with situations where tenants weren't paying rent. That continued on throughout 2020 and into 2021. Yeah, you do it.
Next, Belen. Next slide. This one?
Yeah, that's good. That's good. And then that continued on throughout much of 2021. Finally, in October of last year, we got the COVID-19 Rental Housing Recovery Act enacted. And that started to roll back, sort of even out the playing field between landlords and tenants. That act provided that most of the earlier tenant protections would end as of September 30th of last year. Provided that tenants who can no longer claim COVID financial hardship, they can no longer claim COVID financial hardship as a basis for not paying rent. Initially in October, they were still able to file for emergency rental assistance. And only if that assistance was denied could an eviction be pulled. And then the 3-day notice had to have specific language in it about that emergency rental assistance. But that window closed up too in April of last year. That's when the emergency rental assistance program permanently closed. And people with applications period could still process those up until June. As of June of this year, that's all gone. So it's no longer necessary for a landlord that has a defaulting tenant to prove that they sought rental assistance, that they couldn't get it. None of that stuff matters anymore. Pretty much back to the playing field we had before the pandemic, with one exception. The statewide law that was enacted preempted all local, like county rules, city rules, and what have you. But the Rental Housing Recovery Act provided that that preemption would no longer be in effect. So now what we've got, we no longer have state and federal laws or judicial council emergency rules interfering with the ability to deal with defaulting tenants. But what we do have is the resurgence of county and local rules that we have to be aware of. LA County in particular had a pretty aggressive rental moratorium, eviction moratorium that we had to deal with. And passage of the state act that eliminated preemption, all of a sudden that rule, those ordinances are back in effect. So you've got to pay attention to whatever city you're in, whatever county you're in, you got to look at whatever local rules might be in effect that have to do with your relationship with the tenants.
Next.
So here we are today, we're getting back to business as usual, pretty much for landlords. There's still quite a bit of rent arrearages that are out there that are to be collected by landlords. We've got that issue to deal with.
Jim, apologize. Yeah, the audience joining us virtually.
Yeah, I get too comfortable here.
Yeah.
No, we're good. No, we're good. Yeah, that's fine. That's good. No, we're good. Okay. Anyway, so landlords are no longer required to apply for emergency rental assistance. We're back to a standard 3-day notice. If you guys were involved at all in property management or ownership, you know, the way you went about evicting somebody was crazy for the last couple of years. Every 2 or 3 months, the 3-day notice forms were changing. For a period of several months, it wasn't a 3-day notice, it was a 15-day notice. And it varied depending on when the default occurred and what month's rent was owed. That's all behind us now. We're back to a standard 3-day notice to pay rent or quit in most situations. I mentioned the local county and city rules that you have to pay attention to. And in particular here, I imagine most of you are dealing with property in LA County. LA County moratorium had gone away back in 21 for a period of a few months. It's now back again, starting in April of this year. And it's effective through the end of the year, unless something changes. And that county moratorium provides for rent freeze for certain rent stabilized units and mobile home spaces. It provides protection to tenants from eviction for no fault reasons, or for nuisance, or for unauthorized occupants or pets. So if you are a landlord and you simply want to tenant out just because, it may not be possible to do that without jumping through some additional hoops in LA County. The LA County moratorium also has provisions preventing harassment of tenants, retaliation against tenants, both residential and commercial. And it has some particular eviction protections for low-income households. So if you own or manage property in LA County, you really need to be aware of this moratorium and understand that it's going to be in effect at least through the end of the year. My suspicion is it's going to be in effect through most of next year and maybe beyond as well. Because the history of this moratorium is that every time it was coming up to terminate, the LA City Council moved to extend it a couple 3 months at a time. Several times they did that. So I would expect this is going to be with us for quite a while, if not permanently. Next, please. So let's turn now for a minute and talk about contract performance. I'm sure probably all of you have dealt with situations where a buyer or maybe a seller claimed they weren't able to go through with the deal because of the impact of COVID on their lives. And that caused a lot of heartache. It led to a number of new car forms that were in your standard library of things attempting to deal with that. Basically, as far as the law goes, there's no general relaxation of contract obligations as a result of COVID-19. There are a number of federal, state, and local government actions that provided some protection to parties to a contract. Mortgage loans, for example. People were entitled to exercise forbearance rights under the Federal CARES Act for several months. That's now behind us too. We just talked about all the protections for tenants, both at the federal, state, and local level. And there are some procedural protections available too. The statutes of limitation that govern how long you can wait before filing a lawsuit, for example, were extended by the Judicial Council. And some of those things, the impact of those are still being felt. Likewise, the time limits for bringing a case to trial were extended. But other than that, there's no general relaxation of contract obligations because of COVID. What we do have, we've got some legal principles that have been around for a long time, long before the pandemic, that are still possibly in effect now and might come into play in a situation where somebody claims that because of COVID-19, they couldn't perform a contract. I want to talk briefly about three of those. There's a Latin term, force majeure, which essentially means an act of God. And traditionally, that applies to things like hurricanes, and tornadoes, 100-year floods, and horrible things that happen that legally maybe should allow somebody to either get out of a contract or change the way they perform their obligations under the contract. Then there's also a doctrine called frustration of purpose. Somebody can make the required showing that their entire purpose of the contract was frustrated by COVID-19, they might be able to escape their obligations. Same thing for impossibility of performance. Next. Let's talk for a minute about force majeure. That concept's been around and part of our law the whole time the state's been around and goes back to Old English common law. Basically, it's a contract provision that either eliminates a contract obligation or changes the way it has to be performed in the event of a really unforeseen event, like a tornado, for example. You got a contract to sell a house and a tornado comes along and destroys it, the house isn't there anymore. That might be a good example of a force majeure. The thing to remember about that legal principle, though, is that it only applies if the contract includes a provision that says it applies. And the CAR form contracts don't have force majeure provisions in them. So you're probably not going to encounter that in normal practice. Even if the contracts where you usually see force majeure provisions where it might come into effect, commonly commercial lease contracts have those provisions. Other types of commercial contracts have them. And even if you have a contract that has such a provision, it's really questionable whether or not the pandemic would qualify as a superseding event that lets somebody off the hook in the contract. You still have to prove inability to perform because of COVID-19 and not some other circumstance. For example, if you lose your job because of COVID-19 and you're claiming now I don't have the income, that's probably too far removed. It's probably not going to work. And most force majeure provisions don't allow somebody to get out of a contract entirely. More often, they allow additional time for performance. You see that a lot in construction contracts. If there's some tremendous labor shortage or something that wasn't anticipated, that might allow a contractor additional time to complete the work. Next, please. And the doctrine of frustration of purpose doesn't require any particular contract language. So somebody could come in and say, gee, because of COVID-19, the entire reason for this contract was frustrated and I shouldn't have to perform it. And you do see that. I've seen it a few times in my practice. In fact, I had a case recently that resolved it. Commercial tenancy, and the tenant had a business, a check cashing business, and the law changed. And it changed to such a point that their business was legislated out of existence. So we had to deal with that. It's difficult. Frustration of purpose is difficult to prove. You got to show a changed condition that rendered the entire contract worthless to the party who wants to get out of it. You got to also show that the risk was not reasonably foreseeable. You got to show that the contract value was totally or very nearly totally destroyed. Courts are really hesitant to apply this doctrine. So it's unlikely in most situations that somebody's going to be able to escape their contract obligations under the doctrine of frustration of purpose. A related concept is impossibility of performance. Pretty much the same thing as frustration of purpose. It doesn't require any particular contract language to be invoked, but it's difficult to prove. You got to show a supervening event made performance impossible or impracticable. An example I have in the outline is a construction contract after a zoning change. What if you enter into a contract for a contractor to build you a 6-unit apartment project, and then the zoning changes and the apartment projects are no longer allowed in zoning? That might be an example of impossibility of performance. You got to show the non-occurrence of the event was a basic assumption of the parties that they didn't anticipate that possibility. You got to show it wasn't the fault of the person who's claiming they want to get out of the contract based on a possibility. And you got to show that the parties didn't assume the risks of that would happen. And again, just like with frustration of purpose, courts are really hesitant to use this doctrine to let somebody out of their contract. Where these doctrines, where the issue of COVID-19 and contract performance comes up, most common one I've seen is in deposit disputes. Somebody backs out of a deal, they want the contract back, the seller says no. Buyer says, well, wait a minute, it was impossible for me to get a loan because of COVID-19, I got sick, on and on and on. In most situations, that probably is not going to work. I've had it come up several times in deposit disputes. Generally, you know, it's not going to be, it would be a really special set of circumstances where COVID-19 was the basis for somebody to get their deposit back. But it's still argued quite a bit. You still have to deal with it. Specific performance lawsuits where somebody's filing a lawsuit to force a seller to complete the sale of property. I've seen it come up a few times there. Same thing with lawsuits for contract damages for breach of contract. It comes up. The interesting thing about this whole area of law is that we really don't know how the courts are going to respond to it yet. Usually what we get in terms of guidance from the courts are appellate decisions that are published. And it takes from the start of a lawsuit to the point where you can end up with a published appellate decision where the Court of Appeal or the California Supreme Court is saying, this is how we are going to interpret these circumstances. That process takes anywhere from 3 to 5 years, probably closer to 5 years in most situations. Because a lawsuit that gets filed typically takes about 18 to 24 months to resolve. After that, if an appeal is filed, you're looking at another 18 to 24 months typically before the Court of Appeal makes its decision. Then there's some additional things that have to happen before a decision actually gets published and becomes citable law. And the problem we have is that we haven't been dealing with the pandemic for that long. We're 2.5 years since this descended on us in March of 2020. So most of the cases that arose alleging COVID-19 contract issues really haven't even been tried yet. There's a big backlog and we're just getting to them now. So I think it'll probably be another couple of years before we start seeing some appellate decisions that give us guidance as to how COVID-19 contract defenses might be interpreted. Let's talk for a few minutes about risk management of COVID-19. Next. One area that probably was changed quite a bit for all of you for a while was open houses and showings, how you went about protecting yourself and protecting the public and your clients in that situation. And the mandatory things you needed to do in terms of showing property and conducting open houses are pretty much past us. In June of last year, we had the official reopening of the California economy. And since that time, most of the safeguards that were in effect are no longer absolutely required. You don't have to have physical distancing in stores and places of business. You don't have to have mandatory cleaning. Don't have to have posted entry rules. Don't have to have open house capacity restrictions. Don't have to require masks or sign-in protocols or health screening. You know, the question so much now on these things isn't so much what you're absolutely required to do, but The question in my mind is still, what would be a good idea still to do? And for those of you who have been subjected to lawsuits, you know what a crazy time it is, how it impacts your life, both economically and in terms of the time you spend dealing with it. And as far as whether or not you should still employ some of these protective mechanisms in your practice in terms of open houses and showings, a few considerations to keep in mind. First of all, your sellers and clients have a right to insist on them. So if you've got a property listed and your seller says, gee, I don't want a bunch of people trooping through here without masks, you have a fiduciary duty to follow the instructions of your client. So you may need to insist on masks and distancing and some safeguards like that because your client says you need to. Local regulations may still require some things. So even though the state of California doesn't necessarily require masks in all situations, local regulations might. In fact, I just heard on the radio this morning that LA County is finally going to relax their mask requirements to coincide with California law because we dropped to the lowest level of a lower level of risk. But you still need to keep wherever your property is listed, make sure you take a look at local requirements. Your general liability insurance carriers may have some thoughts on what they want you to do or not do in connection with your practice. Wouldn't be a bad idea to look at your policy and maybe make a phone call to your broker to see if there's anything that they want you to be doing. It seems unlikely to me in most situations that somebody would be able to succeed in a lawsuit claiming that they got COVID or were seriously injured because of something that happened in a property showing or an open house. And in my mind, from a legal standpoint, the problem with those cases is going to be causation. Somebody would have to show that they got COVID at your open house and not at the grocery store they stopped at on the way to the open house or not at the party they went to the next day. It would be a real challenge in terms of proving causation. But still, anything you can do to lessen the possibility of getting caught up in a lawsuit is probably time and money well spent. And if I were defending you in a lawsuit where somebody is saying, I went to this guy's open house and I got COVID-19 and got seriously ill and I want to be compensated. In addition to my arguments, you can't prove that that open house caused you to get COVID. I would like to be able to have you up on the witness stand and be able to go through all the things you did to act reasonably and responsibly to lessen that risk. If you can have hand sanitizer out, have a supply of masks ready for people, have a sign-in protocol, all those things really don't cost anything, just minor inconvenience. It would be really, really useful evidence in a trial if somebody's trying to hold you liable for them having gotten COVID. So as far as dealing with the public goes, there really aren't any hard and fast rules. But as far as you guys at your brokerage firms being employers, there are rules you have to follow. And they're pretty detailed and pretty specific. OSHA has a COVID-19 prevention emergency temporary standards that are in effect now. They've been in effect since May. And they're going to continue through the end of the year, if not extended. My guess would be they might be extended at that point. There's a few things we can talk about here. Employee vaccination status is no longer a criteria as to whether or not you need to follow these rules. Basically, the requirements don't vary regardless of whether your employees are vaccinated. One important thing is that these ETS standards do not apply to independent contractors. So if you've got a brokerage office and all you've got in there are independent contractor agents, you really don't have to follow these things, although again, some of them might be a good idea to follow them for practical reasons. But if you do have, you got 100 agents and you got one receptionist, you still got to follow these rules because you got the one receptionist. And in addition to OSHA requirements, you always need to be mindful again, state, local, basically, city and county. And those OSHA temporary standards require employers to develop a written COVID-19 prevention program. And the requirements of that program are pretty detailed. You got to communicate to employees about prevention procedures. You have to identify and evaluate and correct COVID-19 hazards in your office. You've got to provide face coverings in certain circumstances or require them. You've got to advise employees that they can wear face coverings without fear of retaliation. When I was preparing these notes for this talk, I thought, I couldn't believe an employer would retaliate against an employee for wanting to wear a mask, but I guess it's an issue. So keep in mind, you can't do that. If you got an employee and they want to wear a mask, you have to let them wear a mask. Then you've got to follow procedures to investigate and respond to COVID-19 incidents in the office, and you've got to provide COVID-19 training to employees. In addition to those things, there's a few other things. You have to make testing available at no cost on paid employee time to employees who are symptomatic, or employees who have had close contact with a positive case, or employees during an outbreak. And outbreak is a defined term. An outbreak is 3 or more cases in 14 days in your office. A major outbreak is 20 or more cases in 30 days. And what you have to do in the event of an outbreak depends on how severe it was. Another thing you have to do is if you have an exposed employee, you've got to keep them out of the workplace until there's no longer an infection risk. You've got to follow criteria for returning employees to work after they've had a COVID case. You've got to maintain records of COVID cases in the office and report them when required. And that all sounds like it's way too much to possibly handle, but fortunately, the last item here in my outline, CAR has a really good sample COVID-19 prevention plan. And if you run a brick and mortar office and you have 1 or more employees and you need to be mindful of these things, the CAR sample COVID-19 prevention plan would be a good place for you to start. Next, please. What is not required by the OSHA standards are several things. You don't have to require face masks. You don't have to require physical distancing in the office. You don't have to require barriers. You don't have to impose a limitation on the number of people at indoor meetings. And you're not required under these regulations to have any regular schedule of cleaning or disinfecting. Although it would be a good idea, but it's not a requirement. Next. Several things you have to do if there is a COVID-19 case in your office. You got to determine when the infected person was last in the workplace. You have to determine which coworkers may have been exposed to COVID by contact with that person. You got to notify all your employees in writing of the potential exposure within 1 day of learning of it. You got to offer no charge COVID testing. You got to keep infected and exposed employees out of the workplace. You've got to assess whether workplace conditions may have contributed to the infection, whether corrections could be made to reduce possible future. Just for a minute about vaccine mandates. Now, I'm not going anywhere near the politics of vaccine mandates because I would immediately have half of you hate me and half of you think I'm right. But what you need to know as an employer is under the EEOC rules, that's federal law. Employers are allowed to adopt a mandatory vaccination policy for employees, subject to certain exceptions for religious beliefs and disabilities. You can also extend the vaccination requirements in your office to independent contractors as part of the risk management policy. Where it gets really, really sticky is all the exceptions. If an employer does adopt a mandatory vaccination policy, there are exceptions that have to be observed. An employee who doesn't want to be vaccinated may be entitled to get out of that requirement based on his religious beliefs. He may also have health reasons where it's not a good idea, or his doctors believe it's not a good idea for him or her to be vaccinated. And as an employer, if somebody makes such a claim, you probably have an obligation as an employer to consider allowing reasonable accommodations, which could be one of a number of things. You could arrange for physical distancing for the person who doesn't want to be vaccinated. You can insist on health screenings. You can insist on the use of personal protective equipment like masks, or you can allow that person to work remotely. So as an employer, you probably have the right to impose a vaccination requirement. But if you do, keep in mind there are a lot of exceptions and a lot of other principles you're going to have to deal with along the way, possibly. Next. I want to spend just a minute talking about the court system because that has impacted me personally, and because it impacts me, it impacts all of you who I represent. And the court system's really gone topsy-turvy over the last 2.5 years because of COVID-19. For the first 18 months or so of the pandemic, the courts were very nearly shut down. You could still file things, but even filing things was difficult. I had cases where I would submit filings, and because of COVID and work shortages in courts, it would take 3 or 4 months for my case to get filed. And it causes a lot of problems. In one case in particular I filed a lawsuit to buy a title to a piece of property. Ordinarily, I record a list penance the day I file a lawsuit like that, because I don't want anybody else claiming title to that property or attempting to purchase it or doing it while I'm litigating the title issues. And in this particular case, I submitted my paperwork to the court. 4 months later, they still hadn't processed it. Because they hadn't processed it, I still don't have a case number, so I can't prepare a document called a list penance and record it. And what happened in my particular case, during the 4 months before the court finally issued my case number and I was able to get a list penance recorded, one of the properties involved in the lawsuit had been sold to somebody else. And I tried to go after, started to go after that person, but it became apparent pretty clearly that they had no knowledge of our claims, had to let them loose. Yeah, that's the kind of stuff I was dealing with early on. In the last 1.5 years or so, the courts have finally started to come out of this problem. Filings have been working pretty seamlessly, except in a couple of counties I work in. Courts still have a huge backlog of trials. For the first 1.5 years of the pandemic, cases simply weren't going to trial. Courts didn't want you in the courthouses. Nothing was happening. Starting about 1 year ago, that started to be relaxed. In the last year, I think I've been out to trial 8 times. Whereas in the 2 years preceding that, I hadn't gone to trial once. So, and what's interesting about this whole situation is that the court system has probably changed forever because of COVID-19. More and more hearings now are being conducted remotely. I very rarely show up in court for anything other than a trial these days. It's all by Zoom video or the equivalent. Even fairly sophisticated hearings. In fact, a couple months ago, I even tried an entire case all by Zoom video link. None of the witnesses showed up in court. The judge wasn't in court. The court reporter wasn't in court. It was all done as an assemblage of people on a Zoom video link. And surprisingly, it worked pretty smoothly. So basically, that's the court system that went through hell as a result of this. It's kind of on the rebound and things are getting back to normal. So that's what I have. Do you have any questions or want to discuss anything?
Yeah, does anyone have any question? We're running out of time, so I will allow like a couple of questions. Over there, we have one.
I want to know, is there any plan or now or in the near future, how much, because the condemn, how much can the landlord increase the rent? How many percent? 2 years, we don't have a chance to increase it. So is there any plan in your near future that they will allow to increase the percentage of the rent?
I don't know. There are several intersecting laws that have to do with that. The chief one of which is the California law having to do with rent increases and what have you. And I don't want to misspeak and mislead you. I'm not sure what that is currently. I think, I don't know. I would need to look at that for you to make sure you're getting good advice. But I mean, basically we're getting back to the normal rules that were in effect before the pandemic. But there may still be some limitations, especially in local jurisdictions, as to what you can do in terms of rent increases. Yeah, that's been real frustrating for landlords, I agree.
Okay, anyone else? Juliana? Hold on a second. Wait for the mic.
Press the button. Okay, sorry. Because I was at the Property Expo and Dennis P. Block also spoke on some of this, and I was curious about the moratorium because I know that we're going back to normal. And obviously, to be honest, the COVID stuff hasn't really affected like what we do because we're not trying to break any contracts. It's usually the opposite. So, but what I was wondering is, it said up until December 31st, moratorium is back. But only, could you repeat that section a little bit more?
Yeah, LA County moratorium went into effect back in the very early days of the pandemic. And it was extended by city council action from time to time through most of 2021. And it finally sunsetted last year. It came up for expiration and the city council didn't renew it. So it was gone, it was out of the landscape. But then because of the state law that basically rolled back the state moratorium, that again allowed local cities and counties to implement their own moratoria. And LA County brought theirs back right away. That was around April of this year. And it's currently on the books through the end of December, but as I mentioned, I wouldn't be surprised if that doesn't get extended. So.
Okay, thank you, Jim. So on behalf of the WSGBR, we'd like to thank you for your very informative presentation. And after talking about appreciation, Jim, now it is time for our WSGBR drawing. So the attendance drawing, all WSGBR members are included in the attendance drawing. Not all can be displayed, but all are included. The pot today is $875. So good luck to everyone. Jennifer Hunt. Well, you just missed close to $900. So next week will be $900. That's a good number. Okay. Okay, so our donuts got upgraded, if you guys noticed. So beginning this month, we will be serving bagels, yogurt, your gourmet donuts, and pastry. So we will also be giving away a prize each week to those attending in person. So right now, it is time for one lucky member present to win a prize. So we had to pick it. We had to pick.
Chase.
I hope so.
So we have Kimberly. David, when you know that, you have to take a prize. Correct, right? Correct me. Well, the person in charge are not are absent today. David's gonna fill in for me. You gotta pick one gift.
Can they get it? They need to. Your screen. Do you know all over the damn thing?
Congratulations. Okay, thank you. Okay, now we have 3 winners for the Amazon gift card drawing. Winnie Tam. And Stephanie Lee. You won again? And from Happy Home. Samantha Tran. All the winners on the right, on the left corner. Congratulations. Okay, please make sure to participate in our education classes. A list of upcoming classes displayed on your screen. We have the 45-hour BRE licensing renewal on September the 23rd, 9:30 to 12:30. We have the bias override, overcoming barriers to fair housing on Wednesday, September 28, 10 to 11. The cost is free. The first one, the cost is $85. We also have the 8-hour MLO live webinar. It's continuing education on Friday, September the 30th from 9 a.m. to 4:30 p.m. The cost, it's free. And last but not least, the commercial seminar, real estate development perspective in a continually evolving market and tax treatment on build for rent versus build for sale. It's on Tuesday, October 11th from noon to 1, and the cost is free. The WHCBR committee invites you to Taco Tuesday happy hour on Tuesday, October the 4th at the La Chuperia restaurant in Alhambra. So mark your calendar. You'll be there, right? All right. Okay, WHCBR Foundation will be having the annual auction benefiting charity and scholarship. And if you would like to donate any items for the auction, please bring them to the association before November the 10th. Right, Yolanda? Yolanda, you there? You want to see something? I know we'll look forward for that.
I'm so excited because it's back in person, the live auction. And I know you guys hate my squeaky voice, but I'm getting it ready for Thursday, November 10th. But what I just want to do a friendly reminder as you're cleaning out your closets or you're doing your early Christmas shopping, you know, please remember the young kids, our future. And so as we gather the money for the scholarships, so if you can start putting stuff aside, bringing it to the board, bring it to Karen, make sure your business card is on there. We will be accepting gifts, donations, brand new baskets. If you want to bake or do a candy basket, whatever, get creative. Bring it to Karen, make sure your business card is there, and we will be accepting donations up until Wednesday, November 9th. And we really appreciate it, and I know those young kids appreciate it too. So thank you in advance, and have an awesome day.
Thank you, Yolanda. Okay, raffle, 50-50 raffle.
No.
Yeah.
Tomas.
Okay, save the date. For our installation lunch, December the 2nd. Tickets are now on sale. Sponsorship opportunities available. Please call or email Belen Barrios for sponsorship information. The lucky winner, the last 4 digit, 9163. How much is it? $61. Let's keep it up for next week. Okay, what's next? Well, please join us. Please join our next week as we welcome our affiliate panel. Their topic will be inspect before you invest, benefit of home inspection. So once again, congratulations to WHCBR on your 100 years. And thank you everyone for joining our meeting today. The meeting is now adjourned. Thank you.